we will continue to cover the legacy of Justice Ginsburg and look to the future and for more on her legacy and what this absence means on the court. We are now joined by Senior Fellow at the King's College and Constitutional Law expert Mark Smith and Law Professor at the University of Memphis, who also teaches constitutional law and election law, Steve Mulroy. Thank you, gentlemen, both for being here. And Mark, let's begin with you. I would first just like to get your thoughts on the passing of Justice Ginsburg.
Well, Ruth Bader Ginsburg is an American icon. Her greatness is undeniable. Now, even if you disagree with her judicial philosophy and her approaches to making decisions, even if you disagree with that, you cannot deny her importance on American law. Her writings, her lectures, her decisions will be studied by lawyers, by judges, and by law students far into the future, even studied by those who, again, may have disagreed with her approaches to jurisprudence. She is no doubt a legal titan that will be long remembered.
And Steve, your thoughts on her legacy and the impact that she's had that the nation will forever feel?
Right. Well, I agree with everything that Mark just said. She will be remembered for generations, and I teach a lot of her opinions in my constitutional law class. I think she can be remembered not only for the opinions that she wrote on the bench and some of her powerful dissents from the bench, but also as an advocate in the years leading up to her accession to the Supreme Court, where she basically led the charge, the legal charge for women's rights. Basically the Thurgood Marshall of the women's rights movement, and both through her advocacy and through her opinions, she set the legal standards that now apply when it comes to any discrimination on the part of any governmental entity along the lines of gender and any other ground as well. So she really is an icon and will be remembered for a long time.
And I want to take a look at the legal landscape here, because the justices right now are in recess, and there are some major cases still yet to be heard by the Supreme Court of the United States. And I'm just going to put up the list here of some of the major cases here. You have Pareda versus Barr, Torres versus Madrid, Google LLC versus Oracle America Inc., and Tanzin versus Tanvir. And hopefully I'm pronouncing that correctly. Mark, I'll begin with you. We have a 4-4 court right now. What are your thoughts, and what case there stands out as particularly as one that we should really be paying attention to at this time?
Yeah, well, these cases, I would say, in the grand scheme, although they're very, very important to the parties involved, in the grand scheme of constitutional law in America, I would say they're not particularly important cases. They're not like a gun rights case or a case involving, let's say, abortion rights. They're much sort of less significant in the constitutional scheme than those kinds of matters. So as a consequence, I suspect when you look at cases that are not of as grandiose, if you will, as some of these others, you tend to find not 4-4 splits. You tend to see decisions that come out with 7-2 or 8-1. And I think there's a good chance on these 4 cases, you're not going to have to worry about, let's say, a tie. But bear in mind that if you did have a tie in these cases when the justices go into conference to vote, what usually would happen in that situation is they would wait for another justice to join the court, and then they would reschedule oral argument again. They would have another oral argument, and then they would re-vote internally with the odd number of justices. And that's what would happen here if any of those cases you've just displayed are basically tied at 4-4.
And Steve, do you agree with that they may just wait on some of these? And is there anything there that stands out to you?
They may very well wait. Or sometimes, you can have a tie, and that's all right. It just means that the lower court decision stands. Mm-hmm. You may not have as many ties as you might think, because to the extent that any of these cases sort of split along ideological lines, well, we right now have a sort of 5-3 split among conservatives and liberals on the court. Some of these cases that you've mentioned are not really even constitutional cases. Probably the one that is probably the most significant is not a constitutional case, but the Google versus Oracle case, which could really set up the standard for, when we have innovation in the computer science
right,
area.
The tech industry will be watching that one. And I'm so sorry, we are up against a hard
Exactly.
break. In the middle of your answer, I have to apologize. And thank you both for joining us today.